Hello, and welcome to 7 Essential Financial Steps for Military Caregivers and Survivors. Our presenter today is Relationship Manager Seth Schwanwalt. This webinar is brought to you by AAFMAA Wealth Management and Trust, the premier provider of investment management to the American Armed Forces community. Our company is a fully owned subsidiary of AAFMAA, a member-owned mutual aid association that has served America's defenders since 1879. This presentation is neither specific investment nor tax advice. We are bound by a fiduciary standard and are required to offer our clients advice and services that are in their best interests. Please enjoy Seth's presentation. Thank you.
Hello, my name is Seth Schwanwalt. I am a certified financial planner and relationship manager for AAFMAA Wealth Management and Trust. Thank you for joining me today for our webinar, 7 Essential Financial Steps for Military Caregivers and Survivors. You've spent years making decisions to ensure the safety and stability of your military family. Many veterans want to know that if they become disabled or pass away, their loved ones will still be protected and their wishes will be honored. The thoughtful decisions you make today regarding your finances can help provide a secure future for your loved ones. If you are a military caregiver or a surviving spouse, a comprehensive understanding of your finances, assets, benefits, and resources is crucial as you move forward. Here's the agenda that we will follow today. We develop these 7 essential financial steps for military caregivers and survivors because these are the important steps we often review during our financial planning process. Be prepared. Consider a long-term care insurance policy. Create an enforceable will. Consider the strategic use of life insurance. Consider the strategic use of trusts. Title your assets appropriately. And finally, create a financial plan. We know you can't be prepared for everything, but we can be organized to make life a little easier for our loved ones and family. The question we want to try to answer is, how do I prepare my family for the actions they will need to take if I am incapacitated, unable to respond, or pass away? Start with your legal documents, financial statements, life insurance, military records, and important paperwork, and have them in a safe place, in a place they can access during the event. This could be a digital vault, your safety deposit box, or your home, and ensure your family has access. Documents or personal information that may be required to process claims and entitlements include your DD-214, certificate of release or discharge from active duty, your marriage certificate, your divorce decree, your birth certificates, copy of spouse's social security card, dependent and other beneficiary social security numbers, dates of birth, and contact information, VA disability award and rating decision letters, insurance policies, legal documents including wills, power of attorney, and trusts, documents referring to bank accounts, loans, securities, etc. Certified death certificate. Request enough copies from the funeral home for family insurance companies, benefits, and military entitlements. Oftentimes 20 copies will be necessary or more. In addition to having these documents, we also recommend you prepare a list of logins and passwords for your financial email, subscription, and other online accounts. Also prepare a list of organizations that need to be notified, such as clubs, volunteer organizations, alumni associations, and civilian employers. Let your family know of your final wishes, such as burial or cremation, memorial, or full military honor services, and the obituary. Finally, consult with AAFMAA Wealth Management and Trust about investment management and financial planning services, particularly if you have managed your family's wealth during your lifetime. AAFMAA Wealth Management and Trust has a team dedicated to helping families and survivors through their financial situations. The fact of the matter is we are living longer. 2 out of 3 people over the age of 65 will require long-term care. Here's what you want to know to plan for this scenario. But first, before we jump into long-term care, I think I should mention a durable power of attorney, a POA. You need this document because it enables a trusted family member or friend that you select to act as your agent to handle your financial affairs if you are no longer willing or able to do so. Check with your financial institution for any specific requirements that they may have in accepting an attorney-drafted POA, as some providers have their own authorization standard forms they require for their accounts. As it relates to long-term care, during our financial planning process, we stress test this scenario, typically over 3 to 5 years of long-term care, and then assume you die. It is also important to understand your current medical health status and family medical history. If there are cases of dementia, Parkinson's, or Alzheimer's that run in the family, we would recommend a stress test of long-term care expenses that run 10 to 15 years. We discuss long-term care insurance or long-term care settlement options on permanent life insurance policies and illustrate the cost benefit in an alternate scenario. Long-term care insurance is like most other types of insurance. That is, it is designed to reduce a possible financial risk. In this case, the potential hazard involves the cost of caring for someone, usually from a medical condition or an illness. It may not eliminate the financial risk completely, but can substantially reduce it. Additionally, the premiums are not locked in and are subject to change. Insurance premiums are paid at regular intervals, but keep in mind that you must pay premiums for as long as you want coverage. There is no cash value or equity buildup, and most companies can raise premiums at any time without a cap on the increase. Your age and amount of coverage are generally the most important factors in determining premium cost. The elimination period is the amount of time from when someone is in need of services until when they begin receiving benefits from their policy. Elimination periods generally range from 30 to 90 days. A longer elimination period, that is, the longer the person has to wait to begin collecting benefits, can help lower the premium. Most policies also have a limitation on the amount of time it will pay benefits, usually 3 to 5 years, but some plans do offer more flexibility. The policy will indicate the maximum benefit amount when it is issued. Long-term care insurance can also have inflation adjustments added to cover amounts each year. This rider will likely increase the cost of premiums. Finally, on slide 7, do not wait to start setting aside money for long-term care or looking at the long-term care options we outlined above. The longer you wait, the more costly it becomes, or worst case scenario, the option no longer exists. So we covered the importance of being organized and long-term care considerations. Now we will jump into a few estate planning needs, review the current documents you have in place, and discuss with your family and your attorney to make sure they are still appropriate and in line with your overall goals. As a trust company, we do not provide legal or tax advice, as we do not practice law or prepare tax returns, but we do explain and illustrate estate planning techniques to you. You may want to consider these factors so that when you make a decision and go to your estate planning attorney, you know that what you want and why. This will save you time and money in attorney's fees. An important document in the estate planning process is your will. Your will is going to appoint the executor of the estate. This is the person who is going to carefully follow the instructions and wishes of your will. They direct the distribution of your assets or your estate. If you have minor children, the will also appoint a guardian. A few important notes about your will. You can create a testamentary trust. This means that your will creates a trust and directs assets into that trust. The will is not active until the testator's death. It is also important to note that a will is a matter of public record when filed with the probate court. Slide 9. Now, regarding life insurance, we see 3 purposes for life insurance. The first and most common is income replacement. If an income earner of the household has a premature death and his or her income stream ceases, does the surviving family members have sufficient assets and current life insurance benefits to maintain lifestyle, cover education costs for the surviving spouse's lifetime? Also, we need to consider families with a stay-at-home parent that doesn't have earned income from employment, but contributes to the household by managing the home, taking care of the kids, etc. If he or she has a premature death, then the surviving spouse will need to incur additional expenses to hire a housekeeper, nanny, and daycare. Are these additional expenses covered by a life insurance for the stay-at-home parent? Another purpose of life insurance is for liquidity needs. This is more typical for business owners or those heavily invested in real estate with what would be considered to be illiquid assets at the death of the spouse who runs a business or real estate investments. The surviving spouse may not want to sell the business or property during a down market. In this case, life insurance proceeds can provide the cash flow or liquidity needed. And lastly, the third reason for life insurance is pure estate planning purposes. Perhaps your goal is to leave a certain amount of money for children, grandchildren, or charity, and your current assets are not sufficient to fund that goal. So life insurance can be a cost-effective way to provide for that goal if you have a premature death. Upon your passing or the passing of a loved one, notify all other life insurance companies of the death of your member, including service members or veteran group life insurance. Make sure you have a copy of the policy number, and company contact information. Please keep in mind that a death certificate and photo identification may be required. The insurance company may provide you with death claims and settlement options. We at AAFMAA Wealth Management and Trust believe it is best to study these options when the insurance policy is issued, and we recommend that you review these options periodically. For AAFMAA Wealth Management, for AAFMAA members with AAFMAA life insurance, you can call AAFMAA first, and they can initiate these claims with other companies on your behalf and support you through the claims process until payment is received. At AAFMAA Wealth Management and Trust, we review your benefit options, provide financial planning support, and investment management. Finally, on slide 9, consider rolling SGLI payments into an AAFMAA Wealth Management and Trust Roth IRA so that you never have to pay income taxes on your insurance benefits or investment earnings. Slide 10. Consider strategies for trusts. There are a number of different trusts available to accomplish different goals. The main goal is to manage, invest, and preserve trust assets in accordance with trust documents and applicable state laws. The most common type of trust is the revocable trust, sometimes referred to as a living trust. These trusts are created and funded during the grantor's lifetime and can be changed or revoked at any time while the grantor is living and has mental capacity. They can be the main estate planning document partnered with a pour-over will. They provide a seamless management and administration of assets in the event of grantor trustee incapacity with a successor trustee named. Trust documents are typically not a matter of public record. Assets held in trust title, of course, avoid probate. You can name an individual as sole trustee, but this is a big task. Even if the individual is qualified or skilled in the duties of a fiduciary, it is time-consuming and leaves the individual open to potential conflicts with unhappy beneficiaries. You can also name multiple individuals as co-trustees, but this also puts the administrative burden on the people and can create potential conflicts in the trustee decision-making. Having an institution as trustee or co-trustee allows family members or other trusted individuals to provide input on distributions, but leaves other administrative tasks to professional trustees. Again, these are the primary purposes of a revocable trust. Incapacity planning, avoid probate, court supervision, and maintaining or preserving privacy. But this will be defeated if the assets are not retitled into the name of the revocable trust. And this brings us to slide 11. Making sure your assets are titled appropriately. This is a mistake that is overlooked and frequently occurs during the estate process. We will quickly start with life insurance beneficiaries. It is crucial that you review your life insurance beneficiaries. They may include ex-spouses, deceased loved ones, grown children, and/or special needs children. Are the life insurance funds going to the right person, or in some cases, the right trust? When a tragic or unexpected event occurs in our lives, updating life insurance and policies isn't at the top of the list of things to handle. Then it moves into the background and we forget. We encourage everyone to always review these documents, update them, and make sure they align with your overall estate goals. How are your trusts? How are your assets titled? Typically, you can see right at the top of the statement of the asset. This states whether it is in the individual's name, in the name of a husband and wife, or in the name of multiple people. How assets are titled will impact how assets are handled at death. An individual account will transfer by will, and if you do not have a will, then it will move based on intestate laws. This is a situation highlighted frequently in the news with celebrities who die without a will. Joint tenants with rights of survivorship. This will automatically transfer to the surviving tenant. Note that once it moves to the surviving tenant, it comes to an individual account and emphasizes the importance of the will again. Tenants in common. This may be an asset held by multiple family members, and it does not automatically transfer to the remaining tenants. Instead, it will be transferred by the instructions in the will, and if no will exists, then it will transfer based on intestate laws. Finally, trust assets. Oftentimes, individuals and families create trusts and never fund them. Creating a trust is just the start of the process, and we know that creating the trust can be a bit of a long process, but once the trust is created, the assets need to be placed into the trust. An example of this might be if you look at the top of an account statement and see the individual names on the account. This may mean the assets in the account are not in the trust. These account assets must be placed into the trust, and trust name will typically appear at the top of that account statement. It is important to review what assets you intend to put in your trust and review the titling of those assets to make sure they are actually in the trust. Slide 12. Creating a plan. A financial plan closely examines your financial situation and stress tests scenarios around your specific situation. The financial planning process typically takes a holistic approach to understanding your entire financial life. This means that a change or decision on one financial aspect can impact other aspects of your financial life. For example, simply making a decision to contribute 10% pre-tax of your salary to a retirement plan also, 1, decreases your current taxable income, and also means 2, you have less disposable income. Additionally, 3, provides savings for retirement, increases, as number 4, increases your net worth over time, and 5th, you can benefit if your employer provides a match to the retirement plan. The financial planning process will go through data gathering and goal setting. It will review the applicable information and discuss concerns, objectives, goals, and priorities. With married couples, both spouses should be involved to make sure both understand and address their goals, concerns, and priorities because they do not always match up. Following the data gathering and goal setting, the planners will start reviewing everything. Most of the time, there will be follow-up questions to clarify some data. The first reports might typically include a net worth statement, asset allocation, cash flow report, life insurance analysis, and a detailed list of the data and assumptions. During the initial review, you will look at the ownership of assets, that no assets or liabilities were forgotten. The cash flow of income and expenses seem right, and the inflation or cost of living adjustments are agreeable. Then, depending on your goals and priorities, this establishes the discussion for alternate scenarios to illustrate and really provide food for thought. Additionally, this will identify acceptable movable factors with retirement age, adjustment to expenses or savings, and priority of discretionary expenses like cars, weddings, and grad school. Based on income, tax-deductible expenses, tax-deferred savings, projected investment returns, etc., you will have an idea and expectations for each year's income tax liability. Finally, from the portfolio perspective, you will review your risk tolerance, review your current allocation, and then align your risk tolerance, investment strategies, and goals into your plan. Slide 13. Decisions are often easier and better to make with a partner. Life is uncertain. Our actions, however, can be certain. Your financial situation is unique, and the decisions you make should be focused on addressing your main concerns. A financial planner will work with you to help identify your goals and resources, develop a good understanding of your income and expense needs, and suggest ways in which your assets could be invested. Additionally, a planner can review your existing insurance coverage, life as well as property, and discuss how you can best protect your family by developing an estate plan. A financial planner may also be fee-based, paid only for the financial planning engagement and advice provided, or may be compensated by selling investment products necessary to implement the plan. Having a plan in place can help you and your family feel more comfortable when unexpected life events occur. The 7 essential steps we covered today can help prepare caregivers and survivors for life transitions. Many of the topics we covered today are simple approaches to assist with the organization and accountability of your own financial future. Slide 14. Thank you so much for your time today. It has been my pleasure sharing with you the importance of a proactive plan to protect your loved ones in the event of your passing, disability, or incapacitation. We've also discussed crucial documents, resources, benefits, and steps that are required as a military caregiver or surviving spouse. Of course, I look forward to connecting with you to provide you with concierge service that will protect your loved ones and improve your peace of mind. Please reach out to schedule a follow-up conversation in which we can continue to discuss these topics personalized to your family's needs. I look forward to helping you reevaluate and fortify your financial strategy and legacy planning.